Yes, ladies and gentlemen, it's time to start again. Thank you. This hearing will come back to order. I'm going to place in the record by unanimous consent the additional statements of Senator Sherrod Brown and Congressman Tim Ryan. They were unable to be here today, but wanted to make sure their thoughts were known on this hearing. With that, we now recognize our third panel. As I said, career professionals. Ms. Barbara Boberg is Director for Education, Workforce, and Income Security Issues at the U.S. Government Accountability Office, which is a branch of Congress. Mr. Vincent Snowberger is the Deputy Director for Operations at the Pension Benefit Guarantee Corporation. Again, a career professional. Pursuant to the committee rules, I would ask you to rise and take the oath. Do you solemnly swear or affirm that the testimony you will give here today will be the truth, the whole truth, so help you God? Let the record indicate that both witnesses answered in the affirmative, and you've sat patiently through two additional previous panels, so you know it better than I can describe how this is going to work. And Ms. Boberg, you first.
Thank you, Mr. Chairman, members of the committee. I appreciate your inviting me here today to speak about events leading to termination of the Delphi pension plans and the differential benefit payments that resulted. My beat at GAO includes income security issues, and we've heard truly heart-wrenching stories this morning. My testimony today presents a timeline of key events leading to the plan's termination, focusing in particular on decisions allowing General Motors to provide retirement benefit supplements to some Delphi employees, but not to others. This information is drawn from our March 2011 report prepared for Mr. Turner and others and relies on publicly available documents. The story begins in 1999 when the Delphi Corporation, once part of GM, was spun off as an independent company. As part of that arrangement, GM was required to bargain with the unions affected by the spinoff. In those negotiations, GM agreed to provide top-ups to collectively bargained employees, meaning that if something went wrong with the pension plans for these employees under Delphi, GM would make good on their promised benefits. At the time of these agreements, Delphi's hourly plan was not fully funded, meaning that absent a top-up agreement, some benefits could have been at risk. In contrast, at that time, the Delphi salaried employees plan was fully funded. So fast forward to October 2005, when Delphi filed for bankruptcy. The pension plans were underfunded, and Delphi was not planning to make contributions to these plans during the bankruptcy process. Hence, prospects for the plans and the prospect for participants' future benefits got substantially worse. 2 years later, in 2007, Delphi was still in bankruptcy. In its initial reorganization plan, Delphi proposed to emerge from bankruptcy with its pension plans intact, which could have removed the need for top-up agreements, but this proposal fell through. Shortly thereafter, in 2008, GM agreed to take responsibility for about $3.4 billion of net liabilities in Delphi's hourly plan in two phases. Phase 1 took place in September 2008, when GM assumed about $2 billion in plan liabilities. Economic conditions deteriorated throughout the auto industry in fall 2008, as we all know. GM's losses led the company to seek assistance from the federal government. By April 2009, the Department of the Treasury was working with GM to develop a restructuring plan, and by June, GM too had filed for bankruptcy. In May 2009, Treasury had believed that the hourly plan would be assumed by GM, at least for the UAW workers. However, Phase 2 of the Delphi-GM transfer agreement required Delphi to pay GM about $2 billion, and because Delphi, in its bankrupt state, couldn't make such a payment, the Phase 2 transfer never took place. Meanwhile, GM and Treasury both understood that the salary plan would be terminated. In June 2009, as part of an arrangement for GM to emerge from bankruptcy, GM and the UAW agreed to modify wages, benefits, and work rules to be more cost competitive, and agreed that new GM would assume all employment-related obligations and liabilities for their hourly benefit plan. This agreement did not include other unions or salaried employees. Meanwhile, Delphi and PBGC began the process of what we call a distress termination of Delphi pension plans. PBGC estimated that Delphi plans were $7 billion underfunded, with PBGC expected to bear $6 billion of that shortfall, and Delphi plan participants the remaining $1 billion through the application of benefit limitations as required by law. After objections from the other unions and the salaried employees, objections that threatened to thwart Delphi's and GM's future viability, GM entered into a settlement agreement that, among other things, resulted in top-up payments to the unionized workers of the main unions. No such agreement pertained to salaried workers, and this is where the situation lies today. GAO will be reporting more substantively to Mr. Turner and other requesters on these issues next month, and in that work, we will be talking about what precipitated plan termination, what actions were taken to preserve assets for PBGC and the plans, why some employees were topped up and others not, and what was communicated to employees about the termination. And we expect that in mid-December, and unfortunately, I won't be able to talk about that work in progress today. Thank you, Mr. Chairman. That concludes my statement.
Thank you. Mr. Snowbarger.
Good morning, Chairman Issa and other members of the committee. I'm Vince Snowbarger, Deputy Director of Operations at the Pension Benefit Guarantee Corporation, and I also ought to mention at the times relevant to our proceedings here, I was the Acting Director of PBGC. I will testify today about the termination of the pension plans of Delphi Corporation, the nation's largest producer of auto parts, and specifically about PBGC's role. As you know, in July 2009, PBGC stepped in to protect the pension of Delphi's 70,000 workers and retirees. PBGC will cover about $6 billion of the plan's shortfall, but there's also a shortfall of $1.2 billion in benefits that are not guaranteed by the insurance program. Delphi, which is originally an in-house parts manufacturer for GM, was spun off as an independent company in 1999. At that time, GM transferred assets and liabilities from the salaried and hourly pension plans to the newly established Delphi salaried and hourly defined benefit pension plans. GM negotiated with certain unions to provide benefit guarantees if the hourly plan terminated or was frozen at a later date. Delphi began suffering significant losses in January of 2001, and the funding of pension plans deteriorated. On October 8, 2005, Delphi entered Chapter 11 bankruptcy and ultimately liquidated in 2009. The old Delphi ceased to exist. The new Delphi is a United Kingdom company that purchased most of the old Delphi's assets, including its name. After Delphi entered bankruptcy protection in October of 2005, PBGC worked intensively with Delphi, GM, and other stakeholders to keep the pension plans ongoing. As mentioned earlier, during the bankruptcy, Delphi consistently told PBGC and its employees that it intended to reorganize with its pension plans intact. However, Delphi failed to make required minimum funding contributions to the plans, and as a result, liens were triggered on behalf of the plans against the assets of Delphi's non-bankrupt foreign subsidiaries. Beginning in March of 2006, PBGC perfected those liens as the law provided so that the plans had a secured interest against the foreign Delphi entities. In September of 2007, Delphi filed a reorganization plan with the Delphi Bankruptcy Court, and as a part of that reorganization, GM and Delphi entered into a settlement agreement to transfer part of Delphi's hourly plan to GM's hourly plan. Delphi was to continue to sponsor all of its other plans, including the salary plan. That fell through in April of 2008, but in the latter half of 2008, as Ms. Boberg has mentioned, Delphi still anticipated reorganizing bankruptcy, maintain its hourly plans, and merge the hourly plan with the GM hourly plan. And they indeed transferred part of the hourly plan to General Motors for compensation. Unfortunately, Delphi experienced severely declining revenues in the fall of 2008 and the spring of 2009 as GM and other manufacturers sharply reduced production. When Delphi's financing agreement with its debtor in possession, or DIP lenders, was scheduled to expire on April 24th of 2009, Delphi was faced with the prospect of imminent liquidation. On April 21st, 2009, I signed a notice of determination seeking to terminate the 6 Delphi salaried and hourly pension plans to avoid losses to participants in the insurance fund if the DIP lenders were to foreclose on their collateral. PBGC agreed with the Delphi DIP lenders to postpone the effective date of the termination decision to allow the parties to negotiate a resolution of Delphi's bankruptcy. However, in July 2009, as Delphi was being liquidated, the DIP lenders initiated foreclosure, leaving PBGC with no choice but to step in and take over Delphi's underfunded pension plans. I want to emphasize that PBGC treated the salary plan no differently than the hourly plan. The only difference in treatment of the participants resulted from decisions made by GM. PBGC's involvement in the Delphi and GM bankruptcies was limited to the disposition of the pension plans. PBGC did not have any influence in GM's restructuring decisions, including the decision to assume the collectively bargained top-up agreements entered into by the old GM in 1999. In conclusion, Mr. Chairman, companies that sponsor pension plans have a responsibility to live up to the promises they've made to their workers and retirees. Plans come to PBGC because their sponsors have failed to properly fund them. In unfortunate cases like Delphi, where sponsors fail and liquidate, PBGC is forced to and will step in to protect workers and retirees. Be happy to answer questions.
Thank you. Recognize myself for a round of questioning. In June of 2009, General Motors, as you know, received $50 billion in taxpayer money, and it used $2.5 billion of that $50 billion to buy a stake in Delphi, essentially an indirect bailout. In early 2011, Delphi bought back its assets from General Motors. However, GM still owes about $26 billion to the taxpayers, and unless the stock more than doubles, General Motors, the taxpayers will not be made whole at General Motors. So ultimately, that $2.5 billion was in fact simply a pass-through of taxpayers' dollars. It was not within General Motors' means or anticipated means in the foreseeable time. Literally, they need 10 years worth of profits they've never had in modern times in order to come close to paying back the government. So in that scenario, the question I would ask you, first of all, is at the time the PBGC terminated Delphi's pension, did you know General Motors was going to own a large stake in Delphi? Did you know about the purchase?
Obviously, we knew about the interconnection between GM and Delphi, but at the time we made the decision in April of 2009 that the plans were going to need to be terminated, I don't think any decision had been made at that point. Well, I guess there had been a couple of
April to June was pretty close. That's why I asked.
I understand that, but I think it's a significant difference in timing. Again, our decision was based on factors that were beyond what was happening with GM. We were looking solely at
Sure,
Delphi.
and I'm not questioning your termination. It's simply, at that time, I mean, April to June was very, very close. At the time of the termination, were you aware of, obviously, the top-offs and this investment that was literally a conduit of taxpayer money?
My understanding is those decisions had not been made by GM at that point in time.
Did you
To
know
my knowledge.
Did you have any knowledge that it might happen?
We understood that agreement was in place in 1999, yes.
Well, that
What-
agreement expired with the bankruptcy, didn't it?
I don't think it automatically expires. I think they have to reject the agreement. I'm not a bankruptcy lawyer, but I believe they have to, GM would have had to reject those parts of the agreement.
But GM had power to reject all agreements, void all leases, all purchase agreements. That's a standard part of bankruptcy, is you can literally pick and choose what you want to get rid of, and all you have to show is a business reason to do it.
Again, PBGC was not a part of that decision, but I don't disagree with the chairman.
Okay. Well, but it's safe to say that GM's purchase of Delphi is the equivalent of an indirect bailout from the Treasury to Delphi. You'd agree with that $2.5 billion of the $50 billion is essentially a conduit of a loan to GM that passed through to Delphi, and you knew that was anticipated.
I don't know that we did anticipate that in terms of our decision about terminating the plans. No.
is April to June, but let me, am I right to assume that terminating these pension plans made Delphi a more viable company? That these were somewhat anchors to them, the fact that they were at that point underfunded, and unless the market rose, would remain underfunded and would cause dollars to have to be put into them?
PBGC made its decision to terminate the Delphi pension plans because Delphi was going away. It would no longer exist.
But if General Motors, getting $50 billion, had given $10 billion to Delphi instead of 2.5, wouldn't there have been enough money to view it differently?
I suppose.
So-
I don't have any basis on which to make a decision like that.
So if the administration had handed $10 billion in TARP money to Delphi, and I use this point because remember, with Chrysler, we sold Chrysler to Fiat, but we also put the money in out of TARP never to get it back. Is that correct, your understanding?
That's my understanding. And again, whether 10 million would have been the right number or something more than that, sure. That TARP funds could have been used for a different purpose.
Do you have any knowledge as of today, if you had not terminated the fund, as the earlier panel said, would that amount of funds be still able to pay out substantially more than you're currently paying out? That's their allegation, is that the funds were there, they were at a low point. The funds were essentially transferred to you as part of the termination. If those funds were put back into ordinary investments today, would they yield as much as the recipients are getting today, or would it be likely more?
The problem, Mr. Chairman, is that there is no sponsor to turn this plan back over to. Delphi no longer exists.
And retirees are no longer working.
Understand?
Okay, I just want to understand that General Motors, for example, and I said earlier, would have, could have, and should have. General Motors could have taken back the retirees at least and said, your retirees, we're going to fold you back into our plan, and then you wouldn't have terminated had they agreed to be the sponsor.
If there had been another sponsor willing to take over the plan, that's correct.
So it was General Motors' decision to cut and run from its former employees, longstanding former employees, that in no small part played a part in this. They could have made that decision. They considered that decision. It was even in earlier proposals, and they chose not to.
I'm not aware that it was in earlier proposals to take over the salary plan. My understanding was they had a number of times talked with Delphi about taking over the hourly pension plans, but I don't believe the salaried plans were ever treated that way.
So
or considered that way.
The more powerful of the group was considered and ultimately taken care of, while the less powerful, less represented group, in your opinion, was always going to get screwed.
Well, again, I think, I don't
It's
think
a technical term. You remember we used that in Washington.
I have heard the term before, yes. And again, I don't think it's my position to respond to that because we were not a part of those decisions by
But you know,
the Treasury.
there could have been a better outcome than there was by several means that you've described here today.
Well, obviously, the people that lost an awful lot of those salaries, or excuse me, those pensions that were not topped up, obviously could have been treated better.
Thank you. Mr. Burton.
This is a little confusing to me. Did the administration have any hand in any of the decisions that were made?
I want to try to understand the definition here of the word administration.
The president, the people that work in his administration.
If you're talking the task force or the political side of the administration, the answer is no. Not in terms of our decision to terminate the pension plans.
I'm trying to figure out how the topping out decision was made. The federal government, the taxpayer, put all that money into it. General Motors gets the money, and then they decide that the unions are going to be made whole or almost completely whole, but the salaried employees, the hourly employees, are not. And I'm just wondering how that decision was made.
We were not a part of that decision.
Was it
And that was not a part of our decision to terminate.
So it was left up to General Motors.
Again, we were not a part of that process, part of the Auto Task Force's decisions.
You know anything about the Auto Task Force or the decision-making process?
What I read in the papers, and we had some conversations about both GM's plans and Chrysler's plans early that spring.
But you didn't have anything to do with any of that?
Didn't have any, we had no part in the decision about how they were spending
You
those
just
funds.
turned it over to GM and that was it?
We didn't turn anything over to GM, I'm sorry. Our
Explain
focus.
to me real quickly, the process that you went through, because I'm not sure I got it all.
Sure. Our focus in this particular case was solely on the pension plan sponsored by Delphi. Let's think of it as old Delphi, so we don't get confused with what came out. In looking at those plans, we were looking at, are they funded? The answer was no, for all the hourly plans and for the salary plans. None of them were funded as well as they should have been funded, as well as they needed to be funded. The second thing we looked at is
But there was money, when you were asking the question, you said between April and June, they got another $2.5 billion.
Terminated in April, money came in from GM in June. Obviously, it was anticipated at that point.
Did you know that money was, you didn't know that money was coming?
Well, let me
When you made the decision to terminate these plans?
When I made the decision to terminate, when I signed off on the notice of determination in April, no.
And
That was not a part of our
And
consideration.
2 months, had you known, would that have changed your decision?
Well, again, it depends on whether, or the third factor that we look at is there going to be an ongoing sponsor? If, as the chairman posited, Delphi somehow was going to continue and come out of bankruptcy because they were able to get lending from some other source, that would be one scenario. That was not a scenario that existed as of April 21st. The fact of the matter was, as of April 21st, the lenders in the Delphi bankruptcy were ready to foreclose on their liens. Now, they agreed to postpone that a little while longer, and we agreed to postpone taking action on our decision until
And 2
later.
months later, $2.5 billion came in.
Yes.
And,
It did not go.
but that wouldn't have changed your decision at all?
If it would have made Delphi a viable ongoing sponsor for the pension plan, yes, it would. But it didn't.
Ms. Boberg, you said that Mr. Turner asked for information from you, and you said that you couldn't talk about it today, but that you would get it to him in December. Can you tell me why you can't talk about it today?
Because it's ongoing work.
Well, what do you mean
the more-
ongoing work? Do you have any kind of answers at all today?
We have answers, but they could be wrong since it's ongoing work. We want to make sure that we're right when we're reporting to the Congress. We did this interim report in March that was really just a sort of a sequence of events, a timeline, not particularly analytic, from publicly available documents. And you'll note in here that...
How long have you been working on this? I'm just curious.
I want to say about a year. About a year.
About a year, and you couldn't have the information for us today. It has to be after the hearing in December.
Well, that was the schedule. I was notified of the hearing last week.
Thank you.
I'd
I
ask unanimous consent, the gentleman have an additional minute.
Sure, I'll yield you, Mr. Chairman.
And I'd ask you to yield. I might note for the record that GAO is very conscious that in the for-profit education preliminary report that was issued, that was essentially reversed in the final report, the early report, we've chastised GAO for issuing anything that they could not stand behind 100%. So although it is the original schedule, and we'd love to have it faster, I think on behalf of former chairman and myself, we do want you to get it absolutely right the first time when it comes out.
Thank you, Mr. Chairman.
Thank
I
you.
wonder if I might
Of course.
make a remark about the question of who did what and where the money went. And we have done a fair amount of work in another part of GAO on the auto task force and the auto bailout. And we have done some work jointly on GM and Chrysler and how that all worked and how it worked with pensions particularly. We did that about a year and a half ago. And we've made recommendations in that report and prior to Treasury that they really need to be more transparent about how they do this business at the Auto Task Force and with Treasury as a whole. The Secretary of Treasury is not only over the Auto Task Force and everything else in Treasury, he also sits on the 3-person PBGC Board of Directors. It's critically important, even if there is indeed, the steel curtain and that we've heard a lot about, and everyone is doing everything completely without conflict. It's very important that the appearance of conflict not exist as well. And we felt that if they had been more transparent about how all these things were working and when, that would have been very helpful and would help you all in this hearing today.
Thank you. Mr. Turner.
Great, thank you. And I also want to note that, for the record, that there is a GAO response of November 14th that is in our materials that includes the overview of some of the things that you have looked at. So we do have information from you. Mr. Snowbarger, I want to thank you for the responses that I just received November 9th to the questions that I had given you at our hearing of June 22nd. I want to ask you, you're familiar with these,
Yes.
With these answers and
Yes.
these questions. You are under oath. I would like you to affirm the content of these as being truthful and correct.
They were true when I signed it, they're true now.
Excellent, thank you. There's a lot of talk about the issue of the termination. I want to get to the issue of the settlement. The PBC approved the settlement. They were a party to the settlement. We've heard today about these Delphi retirees and really the perception that we all have that this was wrong, that people were, the pension plans were dealt with differently, that some were topped up and some were not. Does this happen a lot with the PBGC, or is this unusual that pension plans would come out of a bankruptcy, a legal proceeding that you're a part of, that there would be a settlement that results in just one group that had a pension from the company versus others being so significantly impacted and others being made whole? Is that unusual?
I'm not aware of any other situation where there was an agreement like this between a former plan sponsor and a union that carried through. I do believe we've had situations where you have multiple plans sponsored by a company, and some of the plans are terminated and others remain ongoing.
I've got 3 topics I want to deal with, ask you about, and one is the issue of conflicts, another is assets and liens, and the other is openness and transparency. And I appreciate that the statement on the issue of the conflict. I'm going to walk you through that a little bit, because in the question that I have to you, of part of what you gave me on September 9th, I asked, please describe the actual conflicts and potential conflicts between the Secretary's duties as a PBGC board member and the Treasury Department's duties as the majority owner of the new GM. And you wrote, we are not aware of any conflicts. And I think our GO representative gave us a great outline of those conflicts. In your testimony, you say, I want to emphasize the PBC treated the salary plan no differently from the hourly plan. The only difference in treatment of the participants resulted from GM's decisions. Well, part of the reason I voted against TARP and why I think people are so upset about all these bailouts is because, that's not really an accurate statement. Participants resulted from GM's decisions, because there was no independent GM. The president had fired publicly called for the firing of the CEO. The Treasury Department is bailing them out. The Auto Task Force reports to the Secretary of Treasury, and the Treasury Secretary is on your board. And when I get to the question that I ask you about the settlement negotiations, you indicate that PBGC notes that attorneys for the Auto Task Force participated along with the PBGC, GM, Delphi, and Delphi's debtor in possession lenders in telephone conversations during which the terms of the PBG settlements were negotiated. I mean, you really have the government there 3 times. General Motors and Delphi being bailed out through the TARP program, is in the stock being owned ultimately by the Treasury Department. You have the Auto Task Force that reports to the Treasury Secretary, and you have PBGC, which has the representation of the Treasury Secretary. Don't you think that since, well, actually I can't find one of them that was on the telephone that didn't have some direct connection with the Treasury Secretary. Don't you believe that can result in conflicts?
I can only speak to PBGC's side of things. When decisions are made to terminate plans, we keep our board informed about the actions that were taken.
But in this instance, the board member that you're keeping informed also is in control of the other entities.
Mr. Chairman, I can't speak to all the other roles that the Treasury Secretary has. I can speak to his role as a board member for PBGC, and I can tell you how PBGC interacts with that board. But I don't know anything more about that. I don't know how he...
I perceive it as a conflict. I think GAO will perceive it as a conflict, as was stated. I think certainly the people here today and this committee will. Mr. Chairman, I believe are you going to do a second round of questions?
We will.
Thank you.
Would the gentleman yield? Following up on Mr. Turner, though, it is impossible to have the Secretary Geithner, not know what you intended to do prior to your doing it. Well, it's impossible for Secretary Geithner not to have the ability to order monies made available to General Motors. Well, it's impossible for him not to have influence on the Auto Task Force as to what they might recommend to General Motors that they should do. That's an impossibility. There's no Chinese firewall between Secretary Geithner, and Secretary Geithner. Is that correct?
To my knowledge, no.
Thank you. Mr. Jordan.
Thank you, Mr. Chairman. And I want to just let I do have to leave here after my questioning. I apologize. I got to run to another meeting here in the Dayton area. Mr. Snowbarger, you mentioned you were totally impartial when you initiated the termination of the Delphi plan in the spring of 2009, this April to June timeframe. But did the first restructuring plan, to my knowledge, came out in February 2009. Isn't that correct?
Restructuring plan of which?
General Motors. The overall restructuring plan.
Again, we were not concerned with General Motors.
No, that's not my question. My question is...
I don't know.
The restructuring plan came out in February of 2009.
Okay.
Right? Did you have a chance to look at that plan?
I didn't, but I don't know if our attorneys did or not. Again, we were not focused on General Motors because
The attorney is shaking his head, yes.
So PBGC looked at the plan, and in the plan was the top-off agreement was contained in the restructuring plan in February of 2009. So before you made the initial termination decision in the spring of 2009, you knew about the top-off plan being part of the overall new restructuring plan. Is that correct?
PBGC, I guess it was. When I made my decision and when I signed off, it was not a part of...
You're PBGC, right?
Well, I was the ultimate signer, the ultimate decider about whether or not these pension plans should be terminated.
All I'm trying to get at is you said...
And I'm suggesting to you that that was not a part of my rationale for signing off on that, on those terminations.
But it was common knowledge that that was part of the deal, part of the restructuring plan, correct?
I don't know how to respond. I mean, common knowledge, it was a restructuring plan that fell through as well.
Okay.
My decision was not made on the basis that there were going to be top-ups.
Okay, then let me move on to this. When you were dealing with the Delphi plan, who did you primarily deal with? Was it General Motors, or was it the Treasury Department / Auto Task Force?
Delphi.
You never dealt with General Motors at all?
I'm not going to say we didn't talk to General Motors because, again, they were a potential,
so you did talk with General
rescuer
Motors.
for Delphi.
So
If we could have found a sponsor that would have carried on the pension plans after Delphi, then that's fine. We don't care to take over pension plans when there's a sponsor out there.
I'm just asking about this. When you dealt with General Motors, was it General Motors or was it the Auto Task Force, or could you make a distinction?
I think they were all in the room at the same time when discussions were had.
So it was fair to say you were dealing with the Treasury and Auto Task Force?
And Delphi.
Okay. And during those, did it ever come up in those discussions that did General Motors or Treasury Auto Task Force, when you're dealing, did it ever come up, did they explain why they wanted the top-off agreement to take place? Why they wanted that to be in place?
I'm not aware of that.
Did in those discussions when you're dealing with GM, did it ever come up with why they weren't going to treat the salary the same as they were going to treat the hourly employees? Did that ever come up?
To my knowledge, the only discussion about top-ups were related to the agreements that they'd entered into in 1999.
Okay. Mr. Chairman, I yield back.
Thank you. Mr. Austria.
Can you pass the mic over?
Yeah, sure.
Thank you. Thank you, Mr. Chairman. Deputy Director Snowbarger, I want to ask you about the Pension Benefit Guarantee Corporation versus LTV Corporation case that the PBGC won in 1990 in the U.S. Supreme Court. That case had very similar, I think, facts to the Delphi pension termination. And when LTV went through bankruptcy, it created an agreement with the steelworkers which provided additional payments based on the reduced benefits the retirees received through PBGC and what the retirees would have received if the plans had not been terminated. In that case, PBGC objected to the agreements as improper follow-up on plans. And in fact, one of the main reasons PBGC has policy against follow-up plans is because such plans remove employee resistance as a significant check against termination. Therefore, PBGC sought to restore those pension plans back to LTV, and the Supreme Court agreed. So I ask you, why hasn't PBGC filed a similar lawsuit against GM to restore the union pension plans based on top-up agreements? And I mean, it seems that if this were to occur, then all the windfall payments could be used to fund the salary plan as a fully funded pension with full benefits.
I think there are two significant differences between LTV and Delphi. The agreements that we opposed in LTV were in the context of the LTV bankruptcy case. The agreements between GM and the unions were a matter of contract between private parties. The second major difference...
Private parties both in bankruptcy, right?
No.
In 2005, both were in bankruptcy.
What I'm referring to are the agreements that were made back in 1999.
Subsequently, both entities were in bankruptcy.
Yes, but they weren't in a court setting that PBGC had standing to be a part of complaining about those particular agreements. In 1999, it was the spinoff in a private business setting where those agreements arose. In this situation, where the where the supplements were promised in LTV, that was still in a bankruptcy setting where PBGC was still an active party to the bankruptcy. Second major difference between the two cases that you gave me is that LTV came out of bankruptcy as LTV and then prospered and was able to take on those pension plans. That was what we were arguing. In this case, you have Delphi, who's the sponsor of the pension plans. They go into bankruptcy and they did not come out. You're asking us to turn these pension plans over to General Motors. General Motors does not have a legal obligation to take over those pension plans. That was Delphi's responsibility as of the spinoff of the pension plans to Delphi.
Mr. Chairman, I'd be glad to yield to you because I think a good point made here is that weren't both parties in bankruptcy? You responded to that question because I think that's a very important question.
They weren't in 1999 when the agreements were made.
Well, all right. Well, let me. I know I have one other question. We're short on
Please,
time.
go ahead.
We'll get this on the second round because it's important. But let me ask you this, Deputy Director Snowbarger, that the Delphi employees believe that prior to termination, PBGC overestimated the pension liabilities and underestimated the level of funding. Can you explain to the committee, and I'm interested in knowing how you determine what determinations were made for the Delphi pension plans?
Well, first of all, I want to caveat all this by saying that that is part of the litigation that's ongoing. So I'd rather talk about it in general terms. From what I have seen, and I have seen the Watson-Wyatt report that's been referred to, it's referred to as an adjusted funding target attainment percentage. That is a formula that's specified in the Pension Protection Act, or at least the parameters are set out in the Pension Protection Act. When PBGC tries to decide whether or not a pension plan is funded sufficiently, we look at it as a termination liability because we presume if PBGC is interested and if PBGC is going to take it over, that plan is terminating and it's not going on any further. There are three major differences in the way we would calculate things. One is the discount rate that's used. And again, one of the earlier people testified if you use a higher discount rate, the liability is lower. We normally use a lower discount rate than are used for ongoing pension funds. A second is, what do you consider the normal retirement age? And our experience is when a company goes out of business, people tend to retire earlier than if a company is staying in business. And so the assumed retirement age that we used is probably lower than the one that was used by Watson Wyatt. And the third thing is the value of the assets and the date when you value those assets. My understanding is the Watson Wyatt report valued assets in the salary pension plan as of October 1, 2008. We valued them at January 1st or January 31st of 2009. I don't think I need to tell the members of the committee what happened between October 8th and January of 2009. There's a significant decline in the market and a significant decline in the assets, and also a significant decline in the interest rate. So you have liabilities that are going up at the time assets are coming down, and a lower retirement age, and it shows it leads to the conclusion that we had that at termination, the Delphi salary pension plan was about 46% funded.
No, my time has expired. Thank you, Mr. Chairman.
We're going to do a second round. You were there in 08 and 09. Isn't it true that everybody's pension plans enjoyed that same precipitous fall? So if I were at General Electric, or I was at General Motors, or I was at heck, dozens of Warren Buffett's various holdings, working for the railroad, wherever I was, I probably had my pension drop by 25 or 30%, meaning it was at least 30% underfunded if it had been fully funded, or the usual 90-some percent. In 08, at that exact low point that you funded, I mean, virtually the bottom, you could have gone to every pension plan there was and said, well, you guys are grossly underfunded, couldn't you?
Correct.
Okay, and nobody was forced to top up based on a moment in time. I mean, and I'm not trying to push you beyond making sure we get the current law. Current law, you mark to market on a date.
Correct.
The reality, though, is had you been allowed to anticipate those revenues over the life of an ongoing use of those revenues, you would never have marked them to the current value, would you? In other words, functionally, those assets, assuming that America didn't go down a rat hole and never come back, those assets were worth a lot more in a relatively short period of time, because everybody knew this was a short-term disaster for which the American people were bailing out all kinds of entities, knowing that good times comparatively were coming back. So part of the problem for Delphi retirees, salary retirees, is you marked statutorily, I understand why you did it, but you marked at literally the worst possible time for valuation.
We revalued by the time we had come to June of, and we continue to revalue as we find out what the assets were actually worth at the date of termination. The biggest problem for Delphi employees is that Delphi no longer exists. There is no plan sponsor.
Well, and that begs
so
the
you
que-
can't. So you can't really assume an ongoing plan when there is no sponsor.
Right. Now, I want to get back to that. First of all, Mr. Austria makes the point that I was making. Very clearly, you had two entities in bankruptcy, and bankruptcy is the Wild West. Companies ask for relief any which way they want to. So there's no question, I think, in anyone in this panel's mind or anyone here today, they could have absolutely reneged on that 1999 agreement. And I assume your counsel have told you that General Motors could have reneged on it, that they could have sought complete relief. Is that correct?
I think it's accurate legally, yes.
Okay. So the idea that it was an obligation just ain't so. It was an obligation for which they could have gotten relief. Now, let me go through one line of thinking, or two lines of thinking. First of all, could General Motors have been a sponsor at amount less than 100%? Could they have taken both of these plans, but had them taken at an adjusted amount when they were transferred, and having them transferred from Delphi back?
I don't know about the adjustment part. I think we've concluded that they could have taken over both of these plans.
They could have taken them over
They're
at
an eligible
100%.
sponsor.
Right, they could have taken over at 100%. But to your knowledge, under existing law, could they have taken them over at 90%?
I don't believe they could. I believe ERISA does not allow cutbacks by the sponsor of benefits that have already been promised.
But the sponsor was gone.
Well,
Does,
if,
let me put it another way, because I want to get to the forward-looking. We'll assume for a moment that,
I thought you had
We'll-
posited that GM was now the sponsor, so
okay, well,
I'm
let's.
misunderstanding.
Right,
this.
what I want to do is I want to go to two things. First of all, let's assume for a moment that the company's gone, these two pensions have not been terminated. General Motors walks in under current law and says, we'll take these, but we can't have the anchor as great as it is. We'll take all the assets and we'll agree to 80% or 90%. And Delphi says to the bankruptcy judge, will you grant us that relief? If that is not available under the law today, either bankruptcy law or ERISA, do you believe it should be available to salvage a greater amount than these salaried Delphi workers had salvaged when you took it over in termination?
I appreciated the comment of the chairman earlier on that I am a career federal employee. I don't have a position on that issue.
But you ain't getting away with that. But nice try.
Right.
I'd ask for unanimous consent. I have additional minute, so ordered. You're a person who has the tools that you have. Would that tool be, and this is where you may not be able to lobby for it, but you do have an opinion on it, would that tool be a good tool for people in your position now or in the future to have if it were made available by Congress?
I think PBGC has taken the position before that we wish we had more tools to keep plans out there for participants. Currently, the major tool that we have is threatening to terminate a plan. If you think that through, that doesn't make a lot of sense for an agency that's supposed to be promoting defined benefit pension plans.
Okay, so we'll take that as it is. The goal here today, obviously, is to try to find out what happened. And you've been helpful on that, and I want to thank you for it, and I know some of the other members have a second round. But prior to adjournment, I won't be speaking to either of you again. I want to thank you for being here. As you said, you're career professionals. You are limited to answering our questions and not lobbying for, and I appreciate that. And I want to thank you for being here and giving us your testimony. And with that, I recognize Mr. Turner for a second round. Oh, I'm sorry.
It's okay, I'm just sitting here.
You know, Dan, I'm going to call you Micah if you're not careful. Okay, here you go.
That's an inside joke, folks.
Former chairman.
Let me follow up. You said that nobody in the administration had any influence on the decision that was made. I mean, there was a meeting.
Well, again, I've never quite understood in the parlance here whether you're including us as a part of the administration,
Okay,
since
well,
we are part of the
let's-
executive
Okay,
branch.
well, the executive branch includes Treasury, doesn't it?
Yes.
Okay. And Geithner and Mr. Bloom were part of Treasury.
Correct.
And they are also part of PBGC.
Mr. Bloom was not.
Well, Mr. Bloom isn't, but Geithner is. They work together, don't they?
Not
I mean, they
anymore.
know each other.
Not anymore, but
Yeah.
yes, they did.
What I'm trying to find out is during your telephone conversations and during the meetings that you had, what went on? What was said by Treasury, who also had a tremendous amount of influence on PBGC? What did they say to you? Did they say, hey, this is what we ought to do? I mean, they went ahead and upped the pension for the union people, but they didn't for the salaried or hourly people. What went on? What was said that made that decision? And you told me earlier, you said, well, the administration had no influence on the decision-making process. Well, Treasury is part of the administration. Geithner's part of the administration. Bloom's part of the administration. I want to know what went on in the meetings that you had, and what did they say? I mean, somebody said something about upping the unions.
Let me-
Somebody said something about not doing it for the hourly employees. and you were on the phone with them, you were talking to them, so what happened?
Number one, let me explain that when I said that they were not a part of the decision I was referring to was the decision about whether or not to terminate the pension plans, which pension plans, timing of that, et cetera. That decision was solely done in PBGC by career employees, as it turns out.
But Treasury is on the board, and Bloom...
They were not a part of the decision. The board is not a part of those decisions.
What do you mean they were not part of the decision? There's 3 people on the board, right?
The day-to-day operations of PBGC are vested with the director of the corporation.
And so they don't have any input on these kinds of...
As a practical matter, for the history of PBGC, no, they have not. We've done that to avoid political influence on those kinds of decisions.
That just mystifies me. I don't know how you can have Bloom, who lied to our committee, and who also was an executive for the Steelworkers Union. He's one of the people that's involved in this decision-making process.
I met Mr. Bloom when we terminated a number of steel plans, yes.
Yeah, and Geithner, and I just don't understand how they were not involved in the decision-making process. But you said they weren't, so I guess I'll take your word for that.
They were not.
Okay. You know, I'm a stickler for people being under oath. When Mr. Bloom testified, he said he didn't say things, and we proved that he did, and he recanted. So it's very important that you remember, because we're going to pursue this.
Like I said, I was the ultimate decision maker on whether or not to terminate these plans, and Mr. Bloom did not talk to me about them, and Secretary Geithner did not either.
None of these meetings on the phone or anything else, there was no influence exerted by Treasury or by the administration?
No, I think we communicated with them that we thought we were going to have to terminate those plans if, in particular,
What
if
did
there
they
was a
say when you
sponsor.
communicated that to them?
They normally did not.
They didn't say
Respond
anything, they
back
just
to them.
listened?
For most of the conversations, I think that's correct.
Thank you, Mr. Chairman.
The gentleman would yield.
I'll yield to you, sure.
I just want to review for the record. Secretary Geithner knew you were going to terminate the plans. Secretary Geithner, through the CHARP, his control of General Motors, and the task force, made sure that the union workers were made whole in a termination, while Secretary Geithner, informed of the termination, allowed the salary workers to be terminated with 30 to 70% loss by not topping it off or taking steps to have them made whole. Clearly, Secretary Geithner was aware of this at all times and had the power and influence to change that.
I can talk to you about what influence he may have had in the decision on the PBGC side of things. I can't tell you what decisions were made
following
on
up,
the Auto Task Force side.
Secretary Geithner left you no choice but to terminate as a result of Delphi not being viable, General Motors not taking it, and the losses experienced by the salaried employees and retirees of Delphi is the result of his not taking steps to make them whole. Well, clearly steps were taken to make the union employees whole. That's your observation, even though your decision, you had no choice.
Mr. Chairman, that's not my observation. That's your observation. All I can talk to you about is the decisions that PBGC made, what went into those decisions, and the only part of that goes into that decision was that there was no plan sponsor going forward.
Thank you.
The plans were basically abandoned.
Mr. Turner.
Would be.
Thank you, Mr. Chairman. I just want to know one thing for the record with respect to your answer on the LTV case.
Okay.
I understand that you're saying that the agreements with General Motors from 1999 predated the bankruptcy. They were not, top-up agreements that were made in bankruptcy. But to buy your argument that there were parties that made an agreement in 1999 is to assume that the parties that were in the bankruptcy were the same. I mean, we don't buy, and no one in this room buys, that there was an independent General Motors in that bankruptcy. That bankruptcy had new parties. The new party was the Treasury Secretary, and that's how it becomes like the case that Mr. Austria is citing of the LTV, because it's not this independent decision-making of affirming this. There is not only this new party, but it's the government. And that's why everyone is so particularly disappointed and upset. And I want to turn to the issue on the liens, because there's, part of the concern that everyone has is, the valuation of assets, but also the termination of the plan, but also what happened with respect to liens. Now, in your written testimony, you indicate that Delphi entered bankruptcy in October 2005, and that they failed to make the required minimum funding contributions to the plans, and as a result, liens were triggered, and that PBGC perfected those liens in March of 2006. In your November 9th answers to me from the June 22nd questions, you indicate when the plan was terminated, PBGC had perfected $195.9 million in liens for the benefit of the salary plan due to Delphi's failure to make statutory required minimum funding contributions. You then say, which is what confuses me, this was the largest lien amount that PBGC could assert under the law because a secured interest exists only to the extent there is a debt. Well, I mean, it's underfunded. They clearly were not during that period making payments. I mean, is it really your testimony that from the period of October 2005, where PBGC went into bankruptcy, up to the point of planned termination, that there was no additional opportunities for the PBGC to assert liens? And we note, by the way, that those liens were largely against foreign assets that had their value. I mean, did you have
That's correct.
You had
There are
no
only-
additional time period from October 2005 until planned termination to assert
There are
any
only-
additional liens?
Yeah, there are only certain events that give rise to liens, and we filed a lien every time one of those events occurred, and it normally is missed contributions. I think, I'm not sure they were actually liens. We also received, I guess that was letters of credit on the waivers that were given by Treasury for funding contributions. But we did receive those back. PBGC doesn't receive any of these, by the way. It goes into the plan. But no, there are only a limited amount of circumstances that allow us to file a lien, and the lien is not for all of the underfunding, it's for the amount of the contribution that was missed.
Right, and you're saying that during that time period, all the way up until termination, you were dealing only with the lien that you had placed, and that was on the foreign assets. Going into then the settlement.
Yeah, let me expand that just a little bit, and I think this is correct, and we'll correct it if I'm wrong. But I believe there were other liens that were filed on behalf of the hourly plan, and when GM took over, took over half of the hourly plan, as Ms. Boberg indicated, I believe those liens expired at that point. So the only liens we're talking about here is about $195, $196 million for the salary plan, and I think there was another smaller amount of liens for some of the other smaller plans. But in terms of the large salary plan, there had been liens, but those were satisfied when GM took over the first half of the hourly plan as they had agreed to.
As you went into the settlement negotiations, you had the liens that had been in place. You relinquished the liens in part for unsecured debt and payments.
Mm-hmm.
As part of the FOIA request, as part of the whole process that the Delphi salary retirees have requested, is that these settlement negotiations, what had been said, the documents that had passed between parties, be made public. I mean, the settlement's over. This certainly is an issue that has taxpayers' dollars. How the settlement proceeded should be both discoverable by them in federal court, but also should be released with respect to FOIA. As we heard from those that have testified, when they have made their request on the Freedom of Information, they get pages that look like this. Government pre-decisional attachment deleted, 34 pages. I mean, the government isn't telling the taxpayers, part of which were the Delphi salary retirees who had their retirements reduced, what were those settlement negotiations, and what was on the table, and who was saying what, and who told who to do what. I don't understand, and I'd like you to give us, as you said, you're the decider. Well, why isn't this information being released? This is public information about public taxpayers.
I think all the documentation that was requested pursuant to FOIA has been produced, with the exceptions that are allowed by FOIA. With the exceptions that are allowed by FOIA.
Okay, now let's emphasize that word, allowed by, which means that you're exercising discretion to hold the documents back. It's not required by FOIA. You have the ability under FOIA to fully comply and release the documents. Will you?
That's a matter under litigation, and when...
No, it's not under litigation. The FOIA request isn't. The subject matter is. You have the FOIA request. You know you have the discretion to release the documents. I personally believe, I know this panel believes, that this is taxpayers' dollars that were handled here. These retirees deserve an answer. Will you release the documents?
Well, let me make clear PBGC does not operate on taxpayer dollars. I understand that you're not drawing a distinction between the amount of money that came from TARP and what PBGC does, but PBGC does not receive taxpayer funding. Second part is, as long as this is a matter of litigation, I'll stay with the decisions that we've made thus far.
Well, I think that's wrong. I mean, I think it is wrong that you not be held accountable in the decision-making that you had. This was a heavily taxpayer-subsidized transaction in the General Motors and Delphi bankruptcy. These individuals have been significantly impacted. I thank the chairman for his push to make you give him the documents so he can make the decision as to whether or not they be released. But you should be releasing those documents.
Mr. Austria.
Thank you, Mr. Chairman. And I would just follow up to what Mr. Chairman was saying as far as the transparency here. I mean, if we want, a level playing field, so to speak, and we want to make sure that things are done right, then there shouldn't be any reason why there should not be full transparency. But let me go back to this valuation of the level of funding. And I agree with the chairman. The timing, and I think you might acknowledge this, the timing in which that valuation was done is when the markets were down. And what was the funding level that you valuated the pension at that time?
Specific dollar amount?
Or percentage, whatever.
Again, when we did our initial review of this, it was about 46% funded.
About 46% funded. Okay. Let me ask you this. When you did the reevaluation, what was the difference?
There wasn't a lot of difference.
There wasn't a lot of difference?
It was still below 50%.
Well, let me ask you, because I'm looking at some information here. It shows that the average funding level for the top 100 pension plans in 2009 was 81%. And that, again, and you made reference to this, there was two independent actual firms that analyzed DSR's pensions and determined that it was actually 86% funded. I mean, those are big differences. I mean, can you further elaborate on and give us your thoughts as to why we have such big differences, other than the timing of when you evaluated?
One is calculating the funded percentage for an ongoing plan. That means there's going to be a sponsor at the end of the day. There was not going to be a sponsor here. Therefore, PBGC evaluates the funding of the plans on a termination basis. And again, on a termination basis, we use an interest factor that's derived from the annuity markets. We use a retirement age that reflects our experience that people retire when their employers go out of business. They retire earlier. And we use mark to market on the value of the assets.
Well, it seems to me that, again, we're going back to transparency here as far as, and I appreciate you disclosing this now because it's important that we understand how you evaluate these pensions plans. But when we look at the average level of the other, top 100 pension plans in 2009 and how they were evaluated, it doesn't seem like we're comparing apples with apples.
Well, Congressman, we aren't. We aren't. Those are ongoing pension plans. Those sponsors are still out there. They're still viable entities. To the extent they are not a viable entity and they are underfunded in the same way that these plans were, then we look to terminate those. You're talking about the funding of all pension plans, and again, not all plan sponsors are in financial difficulty. Delphi was not only in financial difficulty, it went away. It is no longer there. It doesn't exist.
When was the revaluation done as far as with this plan?
I'd have to check. I don't know what the latest valuation is on that. But it would go toward the benefits that are paid to participants. Let me put it this way. We have certain limitations, and I believe one of the earlier witnesses testified to the limitations by law that are placed on us. There are times when we can pay above those limitations for a certain limited group of people. That's for people that have retired or could have retired 3 years prior to the termination date. So that goes back to could have retired in 2006. They fall under a category called priority category 3, and I very frankly couldn't go through the exact calculations how you get there, but it's possible that if assets are sufficient, we can pay benefits above guarantees for those folks. We'll just have to wait and see what the ultimate valuation is of the asset, and that's ongoing. Thank you, Mr. Chairman.
I'm going to take two chairman prerogatives. First, Mr. Turner is going to close the hearing, and second, I'm going to renege on, I've asked my last question. Because I think there's two things I want to make clear. I served on the company that I'd founded when it became public, and our stock traded below certain minimums, and our PricewaterhouseCoopers came to us and said, oh, by the way, because your stock is trading low, because people don't appreciate it at the value of its going concern value, its actual earnings, we're going to make you take a $100 million write-down on your goodwill. And I never understood it. I never agreed with it. But the SEC and GAAP and so on, they just make you do that. I'll never agree that you have to diminish somehow an 80% to a 60% or a 50% for the difference between the two without at least stating that as a going concern, there was 80%. And the reason simply is that if we continue to allow you to do that, then pensions need to be funded at 120%. They need to be funded as though the entity is not going to be a going concern. And by the way, it's not just General Motors. It's the state of California. It's an awful lot of other groups because sovereigns can default. And if they default, then you're stuck with the assets you have. So I think that's an area that this committee and Congress needs to look at is to beg the real question of if you're correct, not as to the early retirement, because I think there's a little bit of wiggle room there, but as to these other diminishments of the amount, then to be honest, 85, 90% just ain't enough. It ain't enough because ultimately we need to be protected, or we need to protect those people who rely on these pensions at a level that if the company defaults or if anyone defaults, the pension is going to be able to pay substantially close to what was promised and not end up where these people did, or for that matter, the United Airlines pilots and flight attendants who today, and I'll use the word enjoy in a terrible way, enjoy the same kind of diminishment that the salaried workers for Delphi do. Let me ask you one last question, and you can respond for the record if it requires more counsel than you have here today. Most of these workers contributed most of their money as General Motors employees. And none of these workers got a real say in being spun off. If they cannot claw back to the parent entity, if they cannot demand that 70, 80% of their retirement, which was really GM retirement, be able to go back to GM, which is still around, then don't we open everyone to a situation, not one in which there was a legitimate spinoff that was intended to work, but to a spinoff that would be just absolutely designed to do in their existing retirees? Because ultimately, anybody could say, well, I'm going to spin off a subsidiary, and I'm going to spin off this, and I'm going to make it all sound good, but I'm basically, after 2 years, going to quit buying from that subsidiary that I set up, and it's going to go bust, and they're just going to be screwed, to use that technical word again. Doesn't Congress have an obligation to ask, shouldn't they be able to claw back to the parent, which they were taken away from involuntarily, or some other remedy that would prevent this from happening in the future, which I believe you're going to say does not exist in the law today?
Well, it doesn't exist in the law today, but PBGC watches those transactions all the time. And if we are concerned that the pension plans are either being transferred to a spinoff that won't be able to sufficiently fund that, or if they see that the assets of a company are being spun off, leaving the pension behind, we try to intervene in those transactions and stop them, or make sure there's some kind of protection for the pension plans.
But isn't it true, both in the case of Delphi and Visteon, the Ford spinoff, that their entire viability was dependent upon continuing to be Tier 1 suppliers at substantially the same revenue as they had been when they'd been part of General Motors or Ford? I mean, that was always the case, is their viability. Delphi had, and I bought from Packard Electric and some of the other divisions for my company, but the fact is 90-some% of their revenues was fathered to, father to child kind of thing. So when you did that evaluation, weren't they completely dependent upon the success of General Motors continuing to buy? And isn't that really why the unions had the 1999 agreement that required General Motors to protect them for an indeterminate period of time? Well, the salaried workers didn't get the same.
Well, there's also the fact that their plan was underfunded when the spinoff occurred.
But under your calculations, they were both underfunded.
No, I've not made any comment about what the funding status was of the salary plan in 1999.
Well, but
And that's the time period I'm referring to, when the spinoff actually occurred.
yeah, but today you gave testimony that shows if you're fully funded and the fit hits the shan, you're going to in fact be underfunded by 30% or more. I mean, the fact is they were underfunded if Delphi did not remain a going concern, and Delphi's going concern was completely linked both to General Motors continuing to be viable and General Motors choosing to continue buying. So they were in a precarious position in 1999, and that's why the unions, on behalf of their portion of the workforce, demanded something. Shouldn't that have been a red flag to your role or your entity's role, that if the union needed it, why didn't the salaried workers, the people who had less power to negotiate, why didn't they need the same guarantee?
I have no response.
I now turn the gavel over to Mr. Turner.
Thank you. Well, don't go because I have to thank you.
Okay.
I didn't want our chairman to leave because obviously one of the things that I want to do is to thank him. Well, I appreciate that. Mr. Chairman, if you had not held the prior hearings that we have had, or Chairman Jordan, the subcommittee under your committee having had inquiries in this and a hearing, we would not know as much as we even know today. But thank you for coming here, for having this hearing. Thank you for granting my request for these retirees to have an ability to speak with you and for this issue to gain additional light. I think we've learned a couple of things, one of which is the fact that the administration was on all sides of this deal. But the second thing, which I want to thank you for, is that we have learned that PBGC has the ability to release these documents, is exercising discretion under FOIA. Some of those documents have been or will be released to this committee, and I know you're going to be reviewing the issue as to what of those the committee might, under its own guise, make public that PBGC chooses on their own accord not to. So thank you for your consideration of that, and thank you for being here today, and thank you for being in Dayton, Ohio.
Well, thanks for inviting me.